All right, so we're back on the record in 2022 CR 7683, Antoine Lynn. So do y'all believe he's competent? Or would it be best for us to have testing done for competency? My concern is that he's telling me that he was hearing voices. And if he's hearing voices, then my question is whether or not when they're saying he violated the condition of not participating in the DDRF, was he competent at that time when he is alleged to have refused?
If I may, Your Honor.
Yes.
The reason why I said I had a question is because I believe it might be borderline because of medications. And I know that what he's explained to me is that they've changed medications. He wasn't taking them. Now he's on different medications. And I know it takes a while. He's been diagnosed with bipolar and schizophrenia. And I don't know how long he's been on these medications. He's been talking about morning meds and night meds, and he's only on night meds. And so I'm not sure exactly where those levels are. And if, based on my initial conversations with him, he fully understood why he was here this morning. So that's where my question becomes, Judge, as being an abundance of caution, Your Honor, with respect to the competency aspect.
All right. So when did you start taking these different medications?
I went there.
No. The medications that you've been on since you're here at the Bexar County Jail, are those different medications?
They just put me on Zyprexa. I was taking 400 milligrams of Sept, so I rented out Sept, seeing a psychiatrist day before yesterday, so she put me on Zyprexa, and that's 10 milligrams. And she gave me something for the E because I wasn't eating.
All right.
So I don't take no morning meds.
All right. So how are these medications feeling for you?
It's okay. I sleep good. I don't have no problem with it.
All right. So let me just explain something to you. Both the state and defense have agreed to have you revoked. And they've said they've come up to an agreement of 16 months. So this is what I propose. I propose we reset this for 30 days to see where he is on his medication. Guess what? If you all still agree to the 16 months, I will follow that. And any time that you're at the Bexar County Jail counts towards your 16-month sentence. But I just want to make sure that, one, you were competent when you were refusing DDRF. And maybe with these new medications, maybe you'll decide that you want to do something different. I don't want a situation where I revoke you, 16 months time, you're out, and then you're back before another judge for a new offense. So what we'll do is I'll recall you for 30 days. Is everyone in agreement with that?
Yes. That's fine, Judge.
All right. So Ms. Ferguson, on this case, can you give me a 30-day reset, please?
October 17th.
All right. So we're going to come back on October 17th. I will remember what your agreement was, which was revoked 16 months. But this is just for me to make sure that you're on your medications, that the medications have taken effect, and that this is something that you really want to do. You understand? All right. Do you have any questions about anything?
Oh.
All right. So here's the thing. When you're taking medications, if you feel as though they are not working or you feel as though they're negative side effects, you have to let your doctor know. You understand?
Yes.
All right. Good luck. Okay. We'll see you back in 30 days.
Thank you, Your Honor. Now, if you excuse.
Yes. Thank you. Thank you for your patience.
No, I just, okay. Good to go. Thanks.
Thank you. Yes, I just need to put them in Odyssey. Okay. Who's here on Frank Torres? Oh, all right. I'm sorry. Just have one step back. All right. Jose Posadas Mata. Yes. And counsel, I'll call you right up after this one. Hello. Let's see what's going on here. All right, how's everything going?
It's going well, Judge. Thank you.
All right. You're in my prayers.
Thank you. I
Okay.
appreciate that.
All right, so on this case, let me see. All right, a motion for continuance was previously granted.
Okay.
So where are we with DNA and everything?
Overall, the discovery's all been done, Your Honor. The affidavit's been filed. We just need a trial date.
All right. And so, Mr. Posadas, are you requesting a trial?
Yes.
All right, how long do y'all expect this jury trial to last?
I'm thinking a day at most, Your Honor.
All right, Ms. Ferguson, I need a jury trial date, family violence. It's a 2-day jury trial.
October 8th.
All right, we'll be back on October 8th. Your plea deadline date has expired. If you wish to enter a plea, I will only accept a plea with good cause. Otherwise, you have to plead open to the court. Do you understand?
Yes, that's fine.
All right, do you have any questions about anything?
No,
All right, you will be brought over dressed for trial in whatever civilian clothing you have at the jail. If you wish to be attired in something different, you'll need to let your attorney know, and then you'll need to sign documentation for a clothing exchange. And counsel, if there's an issue with the clothing exchange, let the court know and we'll see what we can do to help expedite it.
Thank you, Judge.
All right, is there anything else from either side?
Nothing further, Your Honor.
All right, thank you.
You're welcome, Judge.
Thank you.
May I be
Yes, thank
excused,
you.
Your Honor?
Yes. All right, Luis De Leon. Hello.
How are you?
All right, how are you doing?
Pretty good. I thought you were gonna be in Louisiana somewhere celebrating the fact that Texas is now #1.
No, so here's the thing. It's not how you start, it's how you finish. Just ask the Dallas Cowboys. People concerned?
I hope you're wrong, Your Honor.
Why are you trying to bring me down? You know, LSU won,
I'm trying to bring you up with you,
Yeah.
Judge. That's
the
it.
Saints won. You know, there's a lot going on. All right. And I'm sorry, for security reasons, you guys need to switch.
Oh, my bad.
No problem. But yeah, I didn't know Texas. So Texas is #1.
Yeah, and I hear you loudly and clearly on your comments. It doesn't matter where you start, it matters where you end.
It's how you finish. Ask Bugs Bunny.
But I'm hopeful this year.
Yeah.
And I did give up, just for the record, I did give up on the Cowboys a long
Okay.
time. So,
I mean, Elmer Fudd thought he was finishing, but it turns out he was not. Look at Wile E. Coyote. Look how he fit. You know, it's so many stories.
I got you, Judge.
But hey, congratulations though.
Thank you.
All right, so cell phone. Where are we on that?
We provided a copy of it to defense counsel late last week. One other issue, just for the court to consider, is Matt Allen is the trial attorney in this
Mhm.
case. And at this point today, we have a conflict
Mhm.
that should be resolved hopefully by the end of this week.
Mhm.
So we're just asking that the court give us a little more time, maybe a 30-day reset, so we can resolve that issue and Matt can step in as trial counsel without there being any issues.
Ah, so is there a conflict?
I have Matt's cases, Your Honor.
Ah, okay. All right,
That should be resolved. They're going to Medina County.
okay. All right, so this will be the final setting for discovery. And then on this date that I'm going to give you, with the cell phone being given to them, if you're going to change your offer that you previously tendered, you'll need to change it on that date. All right, Ms. Ferguson, I need a 30-day reset on this case.
And just, I'm sorry, so I understand, is the next setting the final plea deadline or is the
Yeah,
next, okay.
The next setting is for you all to sign an acknowledgement of discovery. And on that date, if you plan on changing the offer that was previously tendered, that's the last date you need to do that on.
Okay.
All right.
October 17th.
All right, October 17th. And so on October 17th, I need an acknowledgement of discovery, and offer is due if you're changing the offer. And then the next date after that will be your plea deadline date.
Thank you, Judge.
And I'm extending your plea deadline date because you all have new cell phone information.
Thank you, Judge. We appreciate that.
All right, is there anything else?
Not with regard to,
All right, thank you for dressing appropriately for court. Did you two coordinate?
well, no, I wish we did, but we didn't.
Yeah.
Judge.
All right, have a good one. We'll see what happens with Texas as they continue their season.
May the state be excused.
Yes, thank you.
Judge.
Thank you, Judge.
All right, thank you. Once you sign the reset form, he's excused.
Fine, Judge. And I've got one other case on the docket, but I didn't give him the file.
Okay.
The defendant didn't show up. You still want me to give the file? or-
Yes.
Okay, all right.
Frank Torres,
Israel Navy. Yeah.
Thomas Hill, I understand he's in jail, but he's on the monitor. That's why he's not here. So I'm not sure how we go about it.
okay, so,
Maybe reset it, recall it, next Friday.
no, he needs to be here today, so do you have his information?
He's in jail, but he's on a monitor. I'm not sure. Need to find him.
What do they mean he's in jail, but he's on a monitor?
He's in an electronic leg monitor. He goes and reports to the jail judge.
It's the work release.
All right, so I'm sure
I wanna-
probation has his number.
I'm gonna go maybe recall it for next Monday.
No, call and his number and tell him he needs to be in court. The ELM people know where he is.
Okay.
He's not missing. They know where he is.
Okay, thank you.
You're welcome. All right, Darren Johnson. Who is the prosecutor on this case? The cause number is 2024 CR 2675. All right, if you can come forward.
Yeah.
And I'm not going to ask you anything about your case.
Yes, ma'am.
Ms. Abrams came to me and said there was an issue with the no contact.
Yes, ma'am.
So what I'm being informed is there's a civil case involving Ms. Johnson and the complainant,
Yes, ma'am.
and there's a no contact order. She's representing herself,
Yes, ma'am.
so they can't have the civil case if she's not allowed to have contact with her. So I'm thinking about changing the order to being no contact outside of,
Civil hearing
yes,
or civil proceeding,
yes.
that'd be fine with the state.
All right, so what,
Your Honor, excuse me, I don't mean to interrupt. There's one other thing. With the civil suit, the Clantons are being sued. Part of that is the harassment, the ongoing harassment of notifying me that I'm being recorded when I'm in my yard. Sirens and.
oh, no, no, so
floodlights.
here's the thing.
So
I don't want to get into the
I
facts of this
understand,
case,
but
okay?
They have asked me, the judges over there, to state harassment because the Clantons are claiming that that is nothing that bothers me. So when I'm saying harassment, I'm in my own yard and I hear the notifications, the sirens, the floodlights, the Clantons are now claiming that that's a violation of the protective order. And I have had the police come out and hear this and see this, and I have a police report to that effect. But I don't want to violate any of my protective orders that you have requested that I have no contact. I am in my own yard and I am responding harassment so that I can bring that into the civil suit.
When you say responding harassment, do you mean that you're calling the police or what?
No, when they notify me and I'm walking to my car or I'm walking from my car to my front door and I'm getting blaring sirens, I'm getting notifications, I'm being recorded. I just state harassment. The notifications are you are being recorded and they are being sued for this.
Okay, and so, and then when you get that notification, you say harassment.
Yes, ma'am.
Okay, no, I'm not counting that as a violation. All right, so you are allowed to say harassment.
Thank you, Your Honor. I've been asked to do that by the judges in the 57th district.
All right, so what I'm going to do is there's to be no contact with complainant outside of civil proceedings.
Judge, if we could just add on there, just that primarily, I think she should probably then communicate directly with their attorney, not with the complainants.
If they have an attorney. Sometimes both people are pro se.
Understand.
So for civil proceedings, this is what I mean by that, because you're representing yourself.
Yes, ma'am.
If there's a legal document that the court requires you to send or a legal document that you have to file and give them notice of in order to proceed, that will be okay. But it has to be related to the civil case. Do you understand?
Yes, ma'am. It's a 2021 case and they have orders not to do this from Judge Aaron Haas.
Mhm.
I've gone for a civil restraining order and they have said that they would, rather than have that they would not do these behaviors. So when I go to court, they're claiming that they don't understand how this bothers me and the
Okay,
judges.
so here's the thing. I don't want to get involved in that case. So what I'm telling you is the state has agreed. So you are allowed to have contact with the complainant during civil proceedings. So what does that mean? Anything involving the civil case that you can have contact with them. For example, I don't know who has moved. I don't know who the plaintiff is. I don't know who the movement is, but I do know in order to start a civil suit, certain documents need to be filed. So you're allowed to file those documents. You are allowed to have the complainant served if the complainant needs to be served. But anything outside of civil proceedings, you're not allowed to have contact. If they are blaring things at your house, and when you walk in and it says you're being recorded and you say harassment, that is fine. So that's the court's ruling. Does everyone understand?
Thank you, Your Honor.
All right. And if there's an issue with something and you don't understand, if you can or you can't do it according to my orders, you can always come back.
I really appreciate it because my pretrial monitor was asking that I asked my lawyer, and my lawyer was asking that I asked the pretrial monitor. And so I've been in court and I know that you've said we can come and get clarification. I really appreciate it, Your Honor.
All right. You're welcome.
you
And
so
thank you. You
much.
always dress appropriately for court. I appreciate it.
Thank you, Your Honor. Thank
All
you so
right. Thank
much.
you. Heather Moore.
Good morning, Your Honor. That is on that.
PSI set for the 19th. I
Mhm.
was talking with the state. They have no objection to bumping it. I have a seminar on the 19th. Wanted to move it to the 18th or the.
All right. All right. Have you spoken with probation to
Yes.
see if they have it ready?
Not, they don't have it ready yet. Hopefully it'll be tomorrow.
Well, do you want to speak to them and see if they're going to have it ready tomorrow?
Okay.
I mean, because otherwise sitting in on the 18th will do us no good if it's not going to be ready.
Let
so-
me check with them.
All right. If you'll check with them. Yes.
I went down to Carruthers Court, Judge Angelini was there, he says he needs a prosecutor from here in order to, take the plea.
All right. State. Judge Angelini, there's a plea.
No, it's a not guilty plea, because we're going to be going to a jury trial.
Oh, okay. So Judge Angelini says he needs a prosecutor downstairs in Judge Carruthers Court.
I just gotta make sure, we're lacking one today, so
Okay.
I could go down. I just don't, I guess I'll confer with the judge, determine when we're picking or something.
Okay.
Is that right?
My understanding is we're supposed to take the jury this.
Thank you. All right, Israel Medellin.
Good morning, Your Honor.
Neil Kalfas on behalf of Mr. Medellin. Unfortunately, he's not with us here in court today.
Okay, is it a Cowboys hangover? What's going on?
I don't know. I wish I had a good answer for the court,
All
but
right, so what I can do is I can call it, or if you want to have me wait a little bit, because what's going to end up happening is it's going to be called, and if he's not here, then
okay.
a warrant may or may not be issued.
Well, okay. I will check back with the court later this morning.
All right, so 11:30?
Yes, ma'am. No,
All right,
thank you.
thank you.
Your Honor,
Yes.
you already have it.
Oh, he already has a warrant on this case? All right, who is here on Heather Moore?
I'm here.
We're waiting on an answer.
Oh, okay. All right, thank you.
Carruthers Court's in the basement.
Yes.
The old one does.
You remember where it's.
I'm not gonna hit my computer because it doesn't work over there. Okay, all right, I'll head over there.
Morning. All right, is anyone ready?
Just Moses Martinez.
All right, once they pull the file, I'll take it out.
I think she's already given it to you. It's not a file, it's a paper file.
Let me see. Ah, it got lost in the shuffle.
Oh,
Okay. All right, Moses Martinez. Where's your client? Oh, okay.
I'm just here to submit this. Judge. I believe that there might have been a violation with Ford.
Yeah, so he needs to be here.
Okay, well,
I mean, otherwise the warrant's gonna be issued. If you want, he can come back. I can hold it till 11:30.
11:30.
Mhm.
Let me see if he's on.
Show my phone today for some reason.
I need to put somewhere to look at that.
Let me find. Well, I think it was changed to October the 24th. That's why.
Okay.
Okay. So I'm not late.
You're very,
No way, you're very punctual.
Is that a meeting? Pre-trial judge?
What? All right, Norma,
What's that?
on his client, Moses Martinez,
Yes, ma'am.
see if you can get the pretrial officer and him to zoom in since he's at pretrial.
Okay, that'll be better.
All right, can you get that to Miss Ferguson?
Thank you.
Thank you.
All right, everyone, I will be right back. I know. All right, who's here for Moses Martinez? Moses Martinez. All right. Martin Torres.
Morning, ma'am.
Good morning. All right, so where are we on CPS records?
I don't believe we've received any CPS records yet. I don't know, I don't really think they're important to this case. But with the new prosecutor and everything, I don't think he knew he was supposed to be getting CPS records.
All right, do you know if they've received CPS records?
We request them, I'll need to check and get back on whether, received them yet. Previously did explain, offer defense.
All right, so today is the day.
Right.
For the CPS records.
Yes.
So what I'm gonna do is I'm gonna have you all come back at 1:30. And if the CPS records are not here, then someone from CPS needs to be subpoenaed to be here. So we'll see you back at 1:30, okay? All right, thank you so much for dressing appropriately for court.
You're welcome, ma'am.
Thank you. All right, Anton Harris. Anthony Newton Harris. All right, so where are we on discovery?
I think we have discovery, Judge.
Okay. All right, State, were you able to tender an offer or no?
Judge, at this point, no.
Okay.
But, yeah,
Right.
they need more time, so
All right, Ms. Ferguson, I need a 30-day reset on Harris. All right, we'll be back on October 17th. And what I'll need is an acknowledgement of discovery if you have all the discovery. And I'll also need the state to be prepared to tender an offer.
yes.
All right. Do you have any questions? All right, thank you. All right. Yes, are you ready?
Yes, sure.
And that's on Heather Moore?
Heather Moore, yes.
Judge, that is the PSI officer that is involved in that's on the jury for the other.
Okay,
So we just need a reset date, Judge. I believe they're asking for 2 additional weeks.
okay. All right, are you okay with 2 additional weeks? And is your client in custody?
Yes.
All right, Ms. Ferguson, on this case, it's 2023 CR 3486. If I can have a reset date for 2 weeks, please.
Give me 1 second. September 20th.
All right, so we'll be back on September 20th.
That's 4 days.
No, Norma, 2 weeks.
September 30th, Judge. Sorry.
Okay,
Scared.
thank you.
Thank you, Judge.
You're welcome.
Madam, excuse me.
Yes.
Thanks, Norma. You're getting like me now.
And Norma, did you ask for the pretrial services officer to zoom in?
He's saying that, Dr. Fernandez ran accident in some officer, probation officer from now, he's not here in Bergen.
Oh, okay,
So I gave him the Zoom link to have him Zoom in.
all righty.
I don't know. I don't know.
Yes.
Days today for Christmas.
I'm not even thinking about it. Rosa Montoya. Hello. Thank you for dressing appropriately for court. All right, so where are we on the PTD?
She was accepted and signed the acceptance. They submitted it Friday and again this morning, so
Okay.
she should be being contacted here this week.
All right, Ms. Ferguson, I need a PTD date on Rosa Montoya, please.
October 17th.
All right, October 17th. Once you sign the reset form, you're excused.
Thank you, Jim.
You're welcome. All right, Matt, are you the retained attorney? It keeps listing,
No, for Miss Montoya?
yes.
No, Guillermo Lares.
All right, okay, thank
Yes.
you. Okay.
Yeah.
Okay. Thank you. It's an issue that also. It's different, the height is up there. And then you go to go something called. You can go just those, the eyes out today. He said you can go there. I was like, we should get back to more than he did it, because I just did it. But in the meantime, I'll just.
The same for profit.
I like that one.
You know what you about this judge?
Yes.
Oh, no, that's okay. I can do. You can do. Yes, sir. How would you? Okay.
Christopher Herrera. Hello.
Good morning, Judge.
What happened?
There's all kinds of things that happened. What do you mean?
I know what you were doing on Sunday.
Studying?
What happened to the Cowboys? What's going on?
Oh, the Dallas Cowboys. I'm not responsible for them, Judge, but yeah, it's one game.
Yeah, that's what, and it always amazes me when people, it's one game and then people say the sky is falling. It's like everybody can have a bad day.
Like, it's all right.
All right, so on this case, today is the plea deadline date.
It is, Judge. We're gonna ask for a trial setting at this
Okay.
rate, and I'm going to additionally, there is potentially some mitigation information I need to get together and then discuss with the prosecution about.
Okay.
But we're gonna ask for a trial date at this rate.
And how long do y'all expect the trial to last?
It's 3 days. It's fairly quick.
All right. And you have all of the discovery?
I do, Your Honor.
All right, Norma, I need a 3-day jury trial date. And it's family violence.
I think November 5th, Judge.
Election day?
No. I'm gonna give people a chance, to vote, so we're not gonna have any dates on November 5th.
For December 3rd.
All right, December 3rd. All right, what will end up happening is you're gonna be brought over dressed in whatever civilian clothing you have at the jail. If you wish to be attired in something different, you'll have to do a clothing exchange with your attorney. Counsel, if there's an issue with the clothing exchange, just let the court know.
Yes, Judge.
All right, thank you.
Thank you, appreciate it.
You're welcome.
Maybe, excuse Judge?
Yes.
I've got everybody blowing up my phone. So
Okay.
where are you? And I'm like, Judge Boyd's more important, the various parts.
Oh, thank you. Have a good one.
All right, thank you.
Your client is
Jonathan Saunders. Yes. How are you today?
Elisa Hernandez. All right, so we have an injury well, we have another case and we also have this possession less than a gram case. What is happening with the other case?
So Judge, we want to note that previously our advocate had reached out to the plaintiff in the other case and had contact. She's tried this morning and so far went to voicemail. She went to voicemail. So we're just trying to reestablish contact.
All right, so have you all tendered an offer on this case?
No, Judge, I can.
All right, if you'll tender an offer, and because this case, it's been going on for a while. So, Ms. Ferguson,
Yes, sir.
if you'll set this for a jury trial, I'm sure it's one day, and then what will end up happening is if there's an agreement worked out or something else happens, I'll consider it on that day.
Okay, yeah, just so we're not barred from working it out, because
No,
I
no, no,
don't
you're
want to jump off the cliff until I know I have to.
Okay,
Do you need your trial date?
yes.
November 12th.
All right, November 12th.
It'll be resolved before then. Don't worry about that. I'll talk to you. Okay, 11/12.
Yes,
And then-
thank you.
Thank you.
Monica's client. He hired me. You showed notice of attendance.
That we should be in charge of two days.
Because they have.
Yeah, and they have.
Can I get in line to announce?
Or you get them. Yes, I have not.
I'll let him know.
Yes. All right, Jonathan Saunders.
Good morning, Your Honor.
Good morning. All right. So this is criminal trial division. Are you standing in for them?
Yes, they have.
All right. What is, let me see what page he's on the docket. A second. All right, thank you.
Do you have a copy of the motion of the file or do I need to get it?
All right, so this family violence case is a misdemeanor, correct?
Correct.
All right. So where are you on discovery?
I actually just got hired onto this case a couple of weeks ago.
Okay,
I honestly have put in a request, but haven't had a chance to pull it yet. I will do that.
okay,
I noticed we have a trial setting next week, so I'm going to make that a priority.
okay.
Um,
All right, Ms. Fergus, can I have a 30-day reset for discovery?
now,
All right, October 17th, once you sign the reset form, you excuse.
okay, there is one other matter I'd like to discuss,
Yes.
which we set on the docket for today. It's a motion to modify or delete the bond conditions. Mr. Saunders is on a full house arrest GPS.
Mhm.
And unfortunately, that means he can't work.
All right, so have you conferred with the state on that?
I have conferred with the state. They're not in agreement with it because of the pending family violence charge, but he's living in a different residence. He has his own vehicle and he needs to be able to work in order to be able to keep that residence.
All right, have you had contact with the complainant?
We have, and I believe is, that's much, indicated us, it's on just here.
Oh, the complainant is here?
The complainant is here.
Oh, well, let's have a hearing.
Okay. Okay.
All right, court is calling 2024 CR 7906, State of Texas versus Jonathan Saunders. Can I have parties announced for the record for the state?
Danny Rosengart for the state.
For the
Kimberly
defense?
Bush for the defense. And I believe that Ms.
Just
Medellin
one
is out in
second.
the
Are
hall.
you Mr. Saunders?
Yes.
All right. And counsel, you filed a motion to modify bond conditions?
Yes, Your Honor.
All right, state, are you prepared to proceed on the motion?
Yes, sir.
All right, defense, do you have any witnesses?
I do have two witnesses, Your Honor, Mr. Saunders and the alleged victim in this case, Ms. Medellin.
All right, call your first witness.
I'd like to call April Medellin to the stand.
All right, April Medellin.
I believe she's in the hallway, Your
All
Honor.
right, they'll go get her.
I think she can go down to the car.
All right, call your next witness and we'll wait for her to come back.
All right, I may need to send a text to her. Mr. Saunders, can you come up?
All
I'd
right,
like
you
to
raise
call-
your right hand. Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you can lower your hand, state your name for the record.
Jonathan Saunders.
All right, defense.
Okay, Mr. Saunders, you're here today because of a charge of theft of the vehicle and a lesser included of unauthorized use,
Yes.
correct? Okay. And as one of the conditions of your bond, you were required to wear an ankle monitor and be under full house arrest?
Yes.
Okay. With whom do you live?
I
Okay. Where are you living?
live in the trailer.
Okay, where, in Elmendorf, okay. And you stated you lived alone. How much is your rent in this trailer?
It is $1,100 a month.
Okay. Are you going to be able to keep that place to live if you were not able to work?
No.
Okay, how many weeks have you been without work already?
Already since I've been out of job, going on 3 weeks.
Okay, so let me stop everybody. So here's the big $1 million question. The $1 million question is, 1, does he have employment? Yes or no? 2, what would his hours be? And 3, is the complainant aware of this? Does the complainant have any objections to this? That's what I need to know.
Okay. Where are you working and where are you planning on?
I do have employment as of now. I work for DoorDash and Favor, and I can work from 8 to 8 if that's okay.
All right, so DoorDash is probably gonna be a problem unless there's a zone that you all can come up with where he's not allowed to be in a specific zone.
Okay.
Because DoorDash, you can go anywhere.
Yeah,
Is April Medellin the person who you, who's involved in the complaint about the car? The alleged victim?
Yes, yes.
Okay, now, where does she live?
she.
Well, just a second. I don't need to know where she lives. What I need to know is, one, does she have any objection to him having employment while he's on GPS? Two, if you all can decide, and you all can do this off docket, what geographical location, if I allow him to work for DoorDash, what geographical location is he not going to be allowed to go in? That's the information I need.
May I step back so I can
Yes.
find the witness?
Sure. Thank you. All right, just step back for a moment. All right, Gaspar Garcia.
Yes, Judge, I'm covering the case for Monica Gadetto.
Mhm.
Judge,
Yes.
I don't know if you were aware that the 227 has the lowest JN number?
Yes.
Okay.
So what's going to end up happening is your case is going to be transferred to the 227. Okay?
The judge, Mr. Garcia did let us know that he had retained the services of Neo Calphus. And check with Norma, but it doesn't appear that there's any notice of appearance on setting, sorry, on file.
So your attorney, they'll need to file a notice of appearance. Otherwise, this Ms. Guerrero will be your attorney. Do you understand?
Yes.
All right. Is there anything else?
Nothing further, Judge.
All right. Thank you.
Once we get a setting, I'll tell Monica to turn this.
I haven't had a chance to do it, but I will get it into all.
Oh, okay. Yes.
Cesar Gutierrez. Hello. Hi, thank you for dressing appropriately for court. All right, so we have jury trial.
Yes.
Okay. All right, I'll see you all back here this afternoon at 1:30.
All right.
All right. And we'll see where we are.
Thank you, Your Honor.
All right, thank you. Yesenia Cardenas. All right, on this case, my understanding, you all have reached a plea bargain agreement?
We have.
All right, and the case that is the 2024 PF, is that case going to be taken in consideration?
I'm assuming it is, Your Honor.
Okay. Let me check. Let me double check. Yeah, it's it's an unlawful possession of a firearm. Let me give you all the number. Okay.
We can step back and check.
Okay. Do you all need the cause number?
That would help.
It's 2024 PF 07597. You're welcome. Oh, okay.
Problems. Oh, sure.
Oh, that incoming drink. Okay, that's fine. Thank you. And I just put it on there, but I did a send a copy. Okay.
I did, it was.
Okay, yes, I think I sent it. Okay. And then I'll send it to them.
Did. They figured it out. Yeah. Okay, we're gonna pretend like I had an easy time. Yeah, but yes, we. I like to say, okay. May all be points feel shine.
They want. I don't have an officer outside of jail. They're reviewing it, but they want strategy. First on bond, it's rated side on me, it's not here. They can't start it without rating. But I have a question.
All right, bye-bye.
Yes.
Six on Thursday or Friday. Later. Always probably.
Can you all just let me know whenever you're ready? All right, just give me one moment.
NPR, but you going to have. And they're pre-finals, so. I'm not surprised at the matter. So is that what?
All right, Deputy Laura, do you see Anthony Harris on the docket? Oh, first, the number one, okay. There we are. All right, are you all ready on Saunders? All right, come forward. Court is going to go back on the record in 2024 CR 2331. Oh, no, step back for a moment. You defense attorneys. Oh, just have a seat for a moment. All right. We're back on the record in 2024 CR 2331. State versus.
Jonathan Gray Saunders.
Sorry, that's the wrong case. All right, we're back on the record in 2024 CR 007906. Jonathan Saunders. And where we left off, your client was still on the witness stand. Do you have any other questions for him?
Have you done any other kind of work in the past?
Yes, I've been warehousing.
Okay. Is it your intention to seek a job doing warehousing again?
Yes,
Okay, and you would like to have hours open so that that would be a possibility?
yes,
Okay. Now you understand you have a no contact order
yes,
with April Medellin? Okay. And you're going to abide by that no contact order? All right. That's all I have for this witness.
All right, any other questions? All right. You may step off the witness stand if you move to the right. Call your next witness.
I'd like to call Ms. April Medellin.
All right, Ms. Medellin, if you'll come forward. Can you raise your right hand for me? Do you solemnly swear and affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you're gonna have to keep your voice up so the court reporter can.
I do.
All right, you can lower your hand, state your name for the record.
April Medellin?
All right, any questions?
Yes. Now, you're the person who called the police in the case that led to this case we're here on today, correct? That is correct. Okay, and that's the theft of a vehicle with a lesser included of an unauthorized use of a vehicle? That's correct. Okay. Now, Jonathan Gray Saunders, the defendant in this case, you know he's currently on full house arrest, correct? With an ankle monitor? All right. How do you feel about that full house arrest being removed to either just GPS tracking or partial house arrest? Okay. Do you have any objections to Mr. Saunders being able to go out and work? Do you have any objections to him doing something like DoorDash and or Favor? Okay,
All right, so the court reporter can't hear. I can't
No.
hear. Okay, thank you.
all right. Is there any kind of work that he could do that would be objectionable to you? No. Okay. Now, can you think of any reason why you would want for him to remain under full house arrest? Not this time. Okay. So you don't feel that him going out and being able to be out in the community represents any kind of threat to you or to your family? Okay, that's all I have.
State.
No questions, Dr.
All right, so are you the complainant in the assault bodily injury case?
Yes.
All right, so when's the last time you had contact with Mr. Saunders?
The night of the incident.
All
The
right.
next day, actually, when he got arrested.
All right, so when he got arrested, that's the last time you had contact with him? And did he contact you
Correct.
after he was arrested?
Oh, before he got arrested, I had talked to him that day, but after that, after he got arrested, I haven't heard from him.
All right, do you all have any children together?
No, just my kids, his stepchildren.
All right, so were you all allegedly, did you all live together?
Yes,
All right. And do you know where he's living now or who he's staying with? All right. So if the court were to lift the no contact order, what that would still mean is if he's working, he still can't have contact with you. So if you were to call him and contact him and he answered, or you all decide, we want to get back together, and he comes over to your house, if the police end up going to your house and he's there, whether you want him there or not, he's going to get arrested. Do you understand that? All right. Do you have anything you think that I should know regarding Mr. Saunders? All right. Thank you so much for coming down. All right. Thank you. You too.
Thank you very much.
All right.
Ms.
Yes,
Medley.
I'll hear argument. It's your motion.
Your Honor, people need to be able to work in order to fulfill their commitments to themselves, their creditors, and society. People also need to be able to work because it keeps them occupied, and it is a very good way to get your life heading in a better direction. Mr. Saunders has a place that he's paying for by himself. I would like to very much see him continue forward with that positive momentum. I believe you could tell, at least it appeared to me as though the complaining witness has no current fear of him. There was no tension or drama in the courtroom this morning. And I think that he will be able to meet whatever conditions you set up. And Your Honor, I'm just asking that you grant this motion and drop the monitoring to just GPS tracking and keeping the no contact order in place. And if you wouldn't do that, just give us partial house arrest with liberal hours so that he can make a living.
All right, State.
Your Honor, on this one, so, on the case, on the assault case that happened March 5th, 2024, again, and once he was arrested, there was a no contact order.
I'm sorry, March 5th?
March 5th, 2024, there was a no contact order that was put in place. As defense already questioned one of the witnesses, she called the police on May 2nd, 2024. So it's something that we seriously have concerns about, and picking up new cases as well. So we're going to oppose defense's motion.
Your Honor, I understand the theory of why the state is opposing it. However, my client has testified that he will not violate the terms. My client has not violated these terms since May. Yes, they did happen to end up together in May following the March incident.
What do we mean by they happen to end up together? And I don't want you to get into the facts
I
of your
don't
case.
know too much about the facts, which is why I phrased it in that kind of way, but
All right, so here's the court's concern. State has just informed the court that there was a protective order in March. And I understand that sometimes people have protective orders and then they decide they're going to get back together. And then they live together. And then there's an argument or something happens. Police get called and they see that someone is under a protective order. Do you understand that you are not allowed to have any contact with her? What, is there something that you do not understand about that?
Your Honor,
Yes.
I believe that the time he spent in jail was quite enough to explain to him in no uncertain terms that, in fact, the court is serious about this.
All right, State, he has to work.
Understand.
All right, this is what the court is going to do. The court will give you partial GPS for employment only. You're not allowed to do any type of work that involves minors. You're not allowed to be a home healthcare provider. And these employment situations where it's DoorDash or some other thing where you're driving, Lyft, Uber, you're not allowed to do those things. You need to find employment where it's a brick and mortar location. Do you understand? All right, so this is what the court is going to do. There's going to be partial GPS for employment only. He's allowed to seek employment Monday through Friday from 10 a.m. to 4 p.m. If for some reason there is, I don't know, an interview that is going to happen at 8 a.m., your attorney will need to let the court know. And then more likely than not, I'll probably approve that. Do you understand? Is there anything you do not understand about the court's instructions? If you have contact with the complainant, I do not care if she calls you and you all think you're getting back together, and you go to her home, or you decide to go out to dinner together, if the police end up arresting you, that's going to be a violation of your bond conditions, and you're going to get arrested. And then we're going to have a hearing on whether or not you should remain in custody. Is there anything you do not understand about the court's instructions? All right. Is there anything else?
No, Your Honor.
All right, thank you. Thank you.
Thank you.
Does your client have an email address? Just for notifications, just for him to.
I don't know.
Thank you.
You know what? I know he does, because he actually emailed me.
Thank you.
Pretty good. What's
Israel Medellin, we stick the file up there for something.
Oh, it's still up here.
He's a no-show judge.
All right, just give me one moment.
Neil, did you have to hire on, that's for Garcia?
We did. And we would, but like literally this morning. And I talked to Jason. Jason says there's a co-defendant saying get transferred out here.
Yes, he's going to go. But he's just.
Yeah, like literally, been there for like 2 hours. So, if I've got the cash out. We'll get the notice filed. Is he still here? Is he right? Yeah, that's fine. You're good. Whatever you do.
He needs to be here
For the bond.
for the bond.
Even in 2-3.
Yes. With this. Yes. Yes. So do you want it done?
There's a city.
Oh, we'll just take it every time. Just bring it with you. Correct. Bring that with you.
Oh, well. Bring it. It is.
Yes, it's in the system already, but we don't have to. No, just bring that original with it.
All right, and can you all look and see which case Medellin has where he has a BF? I don't think it's 2020 C. I don't- All right. And so the other case, the 2023 CR 9587.
I can see if he has a warrant on that case as well.
All right, thank you. All right, Mr. Kalfas. All right, I believe that there is a warrant on the motion to revoke, but not on the new case.
Yes, ma'am, Judge.
All right, court is calling 2023 CR 9587, State versus Israel Medellin. Can I have parties announced for the record for the state
Jason Garrett had the honor.
defense?
Neil Kalfas on behalf of Mr. Medellin, Judge.
All right, this hearing was called this morning at 9 a.m. It's now 11:36 a.m. and the defendant has not made an appearance. Defense, have you had any contact with your client?
Unfortunately, Your Honor, I have not. I have sent text messages directly to the phone number I have for the defendant. I've called that number as well. I had been calling it prior to today. In a act of desperation, I sent a Facebook Messenger message, and I've reached out to people that I know that know Mr. Medellin. And so far, those attempts have all been met with negative results. And so for that reason, I apologize to the court and the state, but I realize that the law is the law, and you know, when you have a court date, you're required to appear, and I'm here and ready, but Mr. Medellin is not.
All right. Then on this case, what the court is going to do, state if you have no objections, so that other judges won't touch this on the unauthorized use of the vehicle, the court is going to issue a judge's warrant, remand him without bond. And the reason why the court is doing that is because he does have a contested motion to revoke hearing that's set. And on that case, that's a deferred adjudication, and he's entitled to a bond on that one. But this was previously set in July for a contested, then it was recalled August 22nd for a contested, and then today for a contested. So for that reason, the court is going to issue a judge's warrant under this cause number and remand your client without bond. If your client makes an appearance, the court will reconsider.
I appreciate that, Judge, and again, I apologize.
No, it's not your fault. Thank you.
May I be excused?
Yes.
Thank you, Judge. Have a safe trip.
All right, thank you. John Young, are you ready? John Young, are you guys ready?
No, I'm just confirming, he just.
Okay. All right, thank you. All right, is there, let me see. Moses Martinez. Frank Torres.
It's on page 7. You ready? Yeah.
All right, Sandoval, Chris Sandoval. Court is calling 2024 CR 0823, State of Texas versus Chris Sandoval. Can I have parties announced for the record for the state? Defense,
Sean Sheffield, Your Honor, we're ready.
and are you Mr. Sandoval? Counsel, have you received all of the discovery?
Yes, Your Honor,
Did you review it with your client?
I did.
And Mr. Sandoval, did you review the application for deferred adjudication or community supervision with your attorney? Did you understand it and sign it? Court will find that the state is in compliance with discovery. Did you review the true bill of indictment with your attorney? Did you understand it? Counsel, do you weigh the reading of the indictment?
We did, Your Honor.
State, are you proceeding on the indictment as presented
Yes, Your Honor.
on all counts or just count one?
Count one. Waive other counts.
All right, any objection?
No, Your Honor.
And are you all waiving the enhancement?
Yes, Judge.
Okay.
Yes, Judge.
All right, did you review the document entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions with your attorney?
No.
Did you understand it and sign it in all the appropriate places?
It's not.
Did you understand you're charged with tampering or fabrication of physical evidence with intent to impair as a third-degree felony? Range of punishment is anywhere from 2 to 10 years in prison and up to $10,000 fine. Did you understand?
It's not.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
It's not.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
It's not.
Did you understand by entering this plea, you were giving up those rights?
It's not.
And did you intend to give up those rights and enter into a plea in this case? Counsel, is there going to be an application for deferred adjudication or no?
No, just probation, Your Honor.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
He does, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
I believe so, Your Honor.
Mr. Sandoval, has anyone threatened you, coerced you, placed you in fear to get you to enter this plea?
No.
Anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, the state is proceeding on count one. Punishment is to be assessed at 4 years in the prison. There's a $1,500 fine. State recommends community supervision. They're taking in consideration 2024 PF 09826, 2024 C, is this CR?
CC.
Okay, CC. Ah, they've done the new labeling for county courts. Okay.
Yes, Your Honor.
2024 CC 737376. There's to be restitution, if any, to Alejandro Perez and cause number 2024 PF 09826. Did you understand that to be the plea?
Yes, ma'am.
Defense, is that the plea?
It is, Your Honor.
State, is that the plea?
Daniel has spoken to state, and yes, that is the plea.
All right. Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there been any such motions?
There you go.
Outside the agreement, the state is requesting that your community supervision be for a term of 4 years. There be a TAP evaluation and 200 hours of community service restitution. Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
Then to the offense as charged in count one, how do you plead? Guilty, not guilty, or no contest?
Guilty.
State any evidence.
State office, Exhibit 1 and all of that. No objection.
All right, did you review the document entitled waiver and consent to stipulation of testimony and stipulations with your attorney?
Yes, ma'am.
Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea, you are giving up those rights to have witnesses testify at this phase of the hearing?
Yes, ma'am.
All right. Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
We are, yeah.
Anything you wish to say on behalf of your client?
Judge, we just ask court to follow those recommendations.
All right. Do you have any children?
Yes, ma'am.
What are their ages?
6 and 4.
And before you were arrested, were they living with you?
Yes, ma'am.
All right. What illegal drugs have you used in the past?
Everyone?
All right. How often were you using heroin?
Not much, just a little.
All right, so here's the thing. You need to be honest with me because I'm trying to set up conditions for you so you won't fail. You understand? Because if you fail at this probation, you're looking at 4 years in prison.
All right.
So now's the time to tell me what's going on in your life. 1.
Okay, I'm gonna use regularly.
All right. So you say heroin, anything else?
That's it. That's it.
How far did you go in school?
11. Okay.
When's the last time you had employment?
Well, I was employed before I got locked up.
All right. And doing what?
Training, partnership.
Okay. All right. Is Child Protective Services involved?
No, yeah.
All right. And if you were released, who would you be living with?
I would be living at my mother's residence.
All right. And are there any children living there?
No,
And what's your mother's name?
Rachel Sandoval.
And does she want you living with her?
Yeah. Yeah.
Did you pick up the phone and call her and ask?
Right here. Oh, yeah, you can ask her.
No. Did you
Oh,
call
yeah.
her and ask her? You just assuming she wants you to be there?
Oh, no, that's where I was staying before I got locked up.
And she understands that if you're released, that you will go back.
Oh, yeah, yeah. Yeah, I did call her and ask her. I've been talking to her.
While you've been in jail, you've been talking to her.
All right. And she doesn't have any children living with her?
Mm.
All right. So then why were you telling me you were living with your 6 and your 4-year-old?
No, they were staying with me. At the time, they're not staying with me now.
Okay.
They're staying with their mother.
All right. Court is finding you guilty. The court will sentence you to 4 years in the prison, suspended and probated for 4 years. There's a $1,500 fine that will be probated. Take in consideration 2024 PF 09826, 2024 CC 737376, restitution, if any, to Alejandro Perez, and 2024 PF 09826. There's to be TAP evaluation in custody. Follow all recommendations. There's to be a referral. Let me see your history just a moment. All right, there's to be a referral to felony drug court. Proof of employment within 30 days of release. There's to be no employment as a home health care provider or with minors. Regular reporting by Zoom or in person. regular random UAs, field visits, one time per month until further notice, 200 hours of community service restitution. 100 hours will be deducted upon completion of parenting classes. And I am ordering parenting classes. The remaining 100 hours will be deemed satisfied, and this is voluntary if he completes his GED or if he receives a certificate or something from a trade school. Otherwise, if you don't do those things, you're gonna have to complete the 100 hours. You understand?
Yes, ma'am.
Probation, is there anything he needs? Is there anything else you need from the court?
No, ma'am.
All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it?
Yes, ma'am.
And did you sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, we can go off the record. In this court, in order to be successful, communication is key. If you have an issue, let probation know. If you feel like you're gonna use, let probation know. And I'm sorry, Ms. Abrams, could you add 90 sober support meetings?
Yes, Judge.
Could I have that back, please?
Yes.
Sober support meetings, that's to help you. I know sometimes people think, oh my gosh, this is just something extra for me to do. But sometimes it helps people when they see people who are in the same situation that they are in. And I will tell you, everybody who's successfully completed probation, where I've ordered them to do sober support meetings, they come to really enjoy it. And then the next thing you know, they're leading meetings and they're there every day. All right?
Yes, ma'am. Thank you.
If you feel like probation is not addressing your issue, you can always come back to court, okay? All right, good luck to you.
Thank you.
Hey, Judge, just to confirm that felony drug court will be in touch as well.
Yes. All right, thank you.
Did we serve paperwork for government? There was an issue, but the statement survived.
All right, thank you. All right, Conacher?
Yes.
Yes.
Mr. Garrett?
Hello.
Judge.
Hi, it's always great seeing you.
Thank you, Your Honor. I apologize. I was a little confused as to what's going on, but I think right now it's a bond issue.
Everything?
Yes.
Yes, I think so. Just go.
And so I'm not sure about this bond condition to be released to Haven. I'm not sure what that.
Yeah, I don't know, because the problem is that, well, not really a problem. This case was transferred from another court. So I don't know about, it's just something that the judge in that court ordered. So I don't know.
Well, her mom is here and she will go reside with her mom.
Okay.
She tells me that she's been very active in recovery since all this happened and going to meetings regularly. And
All
those
right.
are things she intends to do, continue to do well on bond.
All right, so do you know, do you know if the state is in agreement with her maybe being released to her mother?
I didn't, Mr. Escobar, would you be, do you have a position? I don't think they're opposed. In fact, we were talking about an offer. We thought we should maybe look at one thing before
Okay.
we can resolve it. But I expect we'll be able to resolve it.
Yes, Judge, there was just one piece that I wanted to do body cam that might
Okay.
shed some light on kind of what's going on.
All right, so I'm gonna address your bond issue, but when do y'all want this case recalled?
It's fine.
That long.
All right, Ms. Ferguson, can I have this recalled in 2 weeks, please?
Yeah, that's good.
The 30th, September 30th.
All right, so we'll be back on September 30th.
And that'll be like a plea or off.
No, it'll just be,
A
for you all
regular
to see
doc-
where you're,
okay.
I'll label it discovery.
Okay, okay.
All right, thank you.
Thank you.
Now, the other issue is the previous judge in the other court ordered her only to be released to Haven for Hope Program jail outreach. And I'm not the one who ordered that. Her case ended up being transferred here.
Yes, Judge.
So I don't know why they put that in place.
That's
But-
why I got released too the last time when I got picked up on these charges originally.
Mhm.
But then I moved back in with my mom and the guy, the director, I called him and told him what was going on and he said that I didn't need to be at the program anymore because I wasn't homeless anymore.
Okay. No, I mean, I understand. So, let's bring mom up here.
She's very stressed, Judge.
Oh,
She's been dealing with my 14-year-old daughter who's not fun.
okay. All right, you're gonna need to step over there. Hello, hi. I'm doing great. How are you doing? Okay. All right, so this court was transferred to this court from another court. So, her attorney is here. And the issue was they wanted her to go to Haven for Hope Program Jail Outreach. So I don't know anything about the facts of this case because I don't receive facts of this case unless we have other hearings. But your daughter may or may not have drug issues, right?
Yes.
And since she may or may not have drug issues, let me stop saying may or may not. It's the court's belief that she has drug issues, right? So
Yes, definitely.
if she is allowed to be released from custody to you, then you're gonna have to play your part. And what I mean by play your part is you cannot enable her because it's not gonna help her. If there's an issue and she's using, you need to put her out.
I have a box full of drugs, cups, in the top of my closet.
Oh, that is awesome.
She's living at my house, it happens random.
All right. So do you have any objections to her staying with you?
No,
And State, are you gonna have any objections to her being released? All right. So if y'all will fill out this form about the address of where she must live and just fill out the address on there, just write it in.
Okay, okay.
And if you all will sign it and write her name and her address. And so you'll need to live with your mom. Do you understand?
Yeah, that's fine.
All right. So what I'll do is I'll lift the order for her to be released to Haven for Hope. And I will put that she must reside with her mom.
Judge.
All right.
Thank you. And we'll hopefully have it resolved.
All right. All right. Are you all ready on Cardenas? All right.
We just fixed something.
Okay, sure. And then after this case, the court is taking its lunch break. All right, court is calling 2024 CR 2331, State of Texas versus Yesenia Cardenas. Can I have parties announced for the record for the state? Defense,
John Young,
and are you Ms. Cardenas?
Yes, ma'am.
Counsel, have you received all of the discovery and did you review it with your client?
yes, Your Honor.
Court will find that the state is in compliance with discovery. In this case, are there any applications?
No, Your Honor.
All right. Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
I do, Your Honor.
State, are you proceeding on the indictment as presented? Any objection?
No, Your Honor.
Okay. All right. Did you review the document entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions with your attorney? Did you understand it?
Yes, Your Honor.
And did you sign it in all the appropriate places?
Yes, ma'am.
Did you understand that you're charged with theft under $2,500 enhanced? Because the state is proceeding as a repeater count, range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea, you were giving up those rights? And did you intend to give up those rights and enter into a plea in this case? Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe she has a rational as well as a factual understanding of the charges against her?
I do, Your Honor.
Do you believe she's currently competent and was legally sane at the time of the offense?
I believe she is and was.
Ms. Cardenas, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Anyone promise you anything other than the plea?
Sorry, Your Honor.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
Are you a U.S. citizen?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Can we go off the record for a moment? All right, so I'm looking at her history because I'm trying to multitask up here. There are prostitution charges, theft charges, which may or may not be related to the prostitution charges. Has anybody talked to her? I don't know if people just want her to do, or she just wants to do her prison time and be done. But if she just does her prison time and be done, we're gonna be back here for prostitution charges and more theft charges. All right, so you would prefer to just go to prison and do your time?
I mean,
Well, I will tell you, people saying this courtroom probation is difficult, and it is. But it's supposed to be designed to rehabilitate people. But what I can tell you, if you have a drug problem, which usually nobody grows up and says they want to be a prostitute, right? Because that's dangerous. It's dangerous with regards to diseases out there. I always tell people there's super gonorrhea now. There's no cure for it. You never know who it's going to be. Is it going to be somebody who's going to want to kill you or something? And you end up being a part of a Lifetime movie, or somebody discovers a serial killer and you're their latest victim? Or either you end up getting some bad drugs or you OD and somebody has to identify your body. So if you want, I will follow this agreement and give you the 3 years in prison if the evidence is sufficient, or I can try to get you help. But what I can tell you, the help you need is inpatient treatment. So it would be inpatient treatment.
well, what kind of inpatient treatment would that be?
Out, see, you can't write your own program. Let me just tell you. You can't write your own program because writing your own program hasn't worked for you. Because if it would have worked, guess what? You wouldn't have all these prostitutions. You wouldn't have all these theft cases. You wouldn't be here. So if you want the just to go along with the 3 years, I'll give you 3 years. But unless there's some sort of intervention in your life, it's not going to work.
Well, I was recently just put on bond, like, I believe it was 2 weeks ago, and I was on full house arrest.
So here's the thing. You have two choices. In my understanding, they gave you two choices. You can either do probation, and it's going to involve inpatient treatment because you need it, or either you're going to prison. And I always tell people when they make the choice for prison, time will pass whether you're in the prison or not. The question is whether or not you want the time that's passing to somehow change your life and put you on the straight and narrow. I don't think when you were in elementary school, people saw you and said, oh, she's going to be a prostitute, and still something in your life happened along the way where you were using drugs and you started selling your body and then all of these other things. But what I can tell you, you need inpatient treatment. That's what you need. But if you're going to continue on this route, is your mom still alive?
Yes, ma'am.
Your mom may end up having to identify your body. Somebody gonna find a body in some field in San Antonio. Maybe somebody will have reported you missing, and then your mom or somebody's gonna have to identify your body. So if you want to do the 3 years in prison, I will give you the 3 years in prison. But if you want the court to give you probation, I will give you probation. Choose now.
Take the 3 years.
All right. All right. So according to the plea bargain agreement, you're proceeding on count 2. Punishment is to be assessed at 3 years in the prison. There's a $2,000 fine. There are no applications. They're taking in consideration 2024 PF 07597. Did you understand that to be the plea, defense?
Yes, Your Honor.
State, is that the plea? Defense is, I'm sorry, Ms. Cardenas, is that the plea? Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places? Did you understand by signing that you're waiving your right to appeal The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? All right. Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Then to count two, how do you plead? Guilty, not guilty, or no contest? To the repeater enhancement allegation, how do you plead? True or not true? State any evidence.
No objection, Your Honor.
All right, did you review the waiver and consent to stipulation of testimony and stipulations with your attorney? Did you understand it and sign it? Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, Your Honor.
Court will find that the defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. After reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will find you guilty, and the court will find the enhancement true based upon your plea of true and based upon states exhibits 1 and attachments. Are we proceeding with sentencing?
Yes, Your Honor.
All right, anything you wish to say on behalf of your client?
Your Honor, unfortunately, the person that, so to speak, sucked her into this lifestyle was her husband.
Mhm.
So he is currently serving time, I believe. And she just wishes to put this whole business behind her.
All right, the court will sentence you to 3 years in the prison. There's to be no contact with minors, no contact with Esmeralda A. Valdez. Take in consideration 2024 PF 07597. Give you credit for any time served. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, Your Honor.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes.
All right. Is that your mom or?
No.
Okay. All right. Thank you.
Thank you.
All right. Have a good day. Oh, and here's this one. This was dismissed. So, yeah. You're welcome. All right, everyone, we're going to take our recess. And we'll be back at 1:30.